Welcome to the Kemp IT Law IT Plus vlog. I'm Richard Kemp, and this vlog is about the compulsory licensing of benchmarks under Article 37 of MiFID. In January 2017, the new rules on markets in financial instruments, MiFID II and MiFIR, come into force. The new rules are at their most radical in the area of data. While data is funny, inert stuff in legal terms, valuable intellectual property and contracts arise in relation to data, and onerous duties can apply. Nowhere is this more the case than with financial market data, a $25 billion global industry underpinned by contract structures that license, restrict, and allocate risk around data use. MiFID II will have a big impact on this market by requiring transparency for trading price data. MiFID II effectively takes the regulatory template for public price transparency that was introduced for equities trading in 2007 by MiFID I and extends it to trading in bonds, OTC derivatives, and most structured financial products. It's in the area of benchmarks that MiFID II's rules are at their most radical. Benchmark is defined broadly as any published rate, index, or figure which is calculated periodically through a formula based on the value of one or more underlying assets or prices, and which determines the price of a financial instrument. As well as covering indices and other generally accepted benchmarks, it actually operates far more broadly, for example, capturing a single rate based on a single underlying linked to the price of a tradable instrument. Article 37 of MiFIR will impose a directly binding regulatory obligation requiring the benchmark intellectual property owner, as the person with the proprietary rights to the benchmark, to license it to all central counterparties and trading platforms, effectively all comers, on fair, reasonable, and non-discriminatory commercial terms. This amounts to a compulsory license requirement on benchmark IP holders. The Article 37 rules could be seen as legislative interference in private property rights, an area where lawmakers have traditionally been reluctant to get involved. In general terms, the only other areas in the IP world where compulsory licenses are applied are certain standards and patents. Article 37 is a definite policy choice away from after the event competition law type regulation of data licensing practices towards mandatory before the event regulation. This is likely to lead to disputes and litigation between benchmark owners and their users. If you'd like to find out more about data law in the financial sector, check out our vlogs, blogs, client alerts and white papers at kempitlaw.com.